So your loved one passed away and left property in their name. But did you know that you have to probate their estate whether they died leaving a will or not? Well, I'm an attorney at law, so let's talk about it. When someone dies testate, that means they left behind a will giving instructions on what they would like done with their property after they pass. If someone does not leave a will, that means they died intestate. But either way, whether they left a will or not, in order for you to get possession and control of their property, you're going to have to probate that estate. If the deceased left behind a will, your attorney will apply on your behalf for a grant of probate in the name of the executor named in the will. Once the probate registry has processed and approved this application, the executor will be granted the grant of probate and can then proceed to distribute the property. If the deceased passed without a will, then your attorney will be applying on your behalf for letters of administration, which will give you the power to distribute the estate based on law. This is usually done by either the spouse of the deceased or their children. And this process, whether by will or without a will, the probate process takes on average 2 to 4 years to complete, depending on if there are any queries from the probate registry. None of the deceased property can be distributed or transferred to someone else's name without first getting this approval from the court. So, for example, if your dad left behind land, money in the bank, or any vehicles, none of that can be transferred over to your name without first getting either the grant of probate or the letters of administration. This has just been a basic breakdown of a much wider and more complicated process, just so you could have a little bit of knowledge of what you're supposed to do. Let me know in the comments below if you knew this already, and follow for more.